they were oversubscribed, and the flight that we could arrange, my lord, is only this afternoon. We did arrange for a replacement witness, my lord, and I was informed only this morning, my lord, that that witness has asked that we should reschedule his evidence. And that is the reason, my lord, why the case cannot proceed today. We submit that it's not due to any fault on the state case. We submit, my lord, that it's due to circumstances beyond the control of the state. As we mentioned the other day, that there are admissions that still need to be ironed out, and we can use the rest of the court time today to try and sort out those admissions. But the case will proceed tomorrow, my lord.
As the court wishes, Your Lordship, the state did approach us, Your Lordship, and inform us about the circumstances. However, we still contend that the state is the driver of the proceedings. At all times, it will remain the fault of the state in certain instances if this matter doesn't proceed today. For instance, Your Lordship, the state should have known before today that if this witness is not available, they will have to get another witness. The witness cannot, Your Lordship, if the state inform them on time and then change that they must be changed to a particular day or schedule. We are always concerned and cautious with regard to the waste of court's time, since the accused are in custody, Your Lordship. The good thing is that the interpreter is here. It doesn't mean that if the interpreter who always appear before the court is not here, the state cannot arrange interpreter. It is the duty of the state to arrange interpreter. Unlike in civil matters, whereby each and every party must arrange their own interpreters, Your Lordship. Even if myself, I came here today, even though I feel like I'm catching flu, but I had to come. The state informed us that the next witness will be here. They arranged a flight to be in Johannesburg, here in Pretoria, after 2. Actually, it doesn't even specify. He said in the afternoon. We're not trying to be difficult, Your Lordship. However, we leave this in the hands of the court, but the court must note our concerns. Lastly, and most importantly, Your Lordship.
So, you cannot be complaining and leaving it in the hands of the court. State your complaint. He has explained his situation. It is either the defense is satisfied with that, or it is not. If it is not, what is the next forward?
Unfortunately, the court did interrupt me. The next statement I will make was going to qualify whatever I said with regard to me leaving it in the hands of the court. Maybe if the court allows me to finish, but I will still stand with our submissions. Or on the previous appearances, Your Lordship, there was a witness who testified, the second witness. I did inform the state that I will address the court in that regard. There was a crew of that state witness I don't know whether he's still constable, but the state name is Matebula, was supposed to follow that witness according to what the state told us before, that Matebula will follow him and testify. Then Matebula state decided not to call Matebula, Your Lordship. Even though the defense already prepared questions with regard to Matebula to establish what really transpired on that day with regard to these two officers. Because even the testimony of Mtetwa, it was not satisfactory to us as the defense. Hence, we wanted to ask further questions to Matebula, Your Lordship.
Well, I don't think you can dictate on the state which witness to call. I think you can complain that we are left with a gap when nothing is happening. I mean, I myself cannot say to Mr. Baloyi, Mr. Tobane says there's a Mr. Matebula, call him. I mean, that's not how it should.
Yes, I agree with the part. But now we must be very careful because the state abuses its status, the right to, as a demandus litis, Your Lordship. For instance, even it transpired that the state is not clear whether they are going to call Makumal or not. It's not that clear, Your Lordship. Hence, the reason why I'm saying this is that we request that the state...
Mr. Tobane, those are not areas we should be discussing now, me and you. He is running the state case. You are running the defense case. What we can complain about is where there's a gap like today and nothing is happening. And I understand. So this case happens to affect people whose locality straddles across the country. And I would have thought that there's a possibility some of them will have traveled from far to be here and nothing is happening. That is a concern. As to whom the state should have been calling and so forth, I don't think it is our call. Honestly, I don't.
Your Lordship, with your respect, with regard to that, my last submission is that may the state indicate to us, not the court, maybe when we meet, which witnesses they are not going to call and which ones they are going to call, then they provide us with those witnesses that are not going to call, Your Lordship. That will be my final submission.
Advocate Ushololo.
Thank you, my Lord. My Lord, the application for the postponement is opposed on the following reasons, my Lord. Yes, we agree. The state is the dominus litis, my Lord. However, it is unacceptable, my Lord, that the court can adjourn and not proceed because of the witness coming from Durban. It is the duty of the investigating officer, my Lord, to bring the witness to court, as well as all other witnesses. If there is a problem, my Lord, with this one witness who is from Durban, there is a list of witnesses who are still supposed to come and testify, and they are all from Johannesburg. The state has indicated, my Lord, that is moving to the area of evidence for the witnesses who were inside in the house. And all those people, they are here in Johannesburg today as we speak. That's Makumalo, that's Kelly Kumalo, that's Zandi Kumalo, that's Longwe Twala. They are all available who were inside in the house. But now we're told that the one who is from Durban is not available and the case is adjourned. My Lord, that's my submission, that that kind of approach is a delaying tactics, my Lord. We should use the court time in using the other witnesses who are available. And the subpoenas, my Lord, I want to believe they were issued warning the witnesses for the duration of this trial. All of them, they have to be lined up outside in court. That is the duty of the investigating officer and the prosecutor who is dealing with this matter. And they are failing to do that, my lord, at the expense of the delaying in this case. Therefore, I pose the application for the postponement, my lord. Any witness who is available in Johannesburg must be called to come and testify today, as the court pleases, my lord.
Uthi-ke bekufanele ukuthi umsheshisi ukwazile lokho ngaphambi kwesikhathi ukuthi lo fakazi akazi ukuthi bese-ke enza ukuhlela ukuthi abe khona ubufakazi bozobuyiswa ukuthi icala likwazi ukuqhubeka. Lilonke-ke ummeli kuthubane uzwakala njengobajabuli ngokuthi icala liphuthiswe ngena afakazi bonke. Nommeli futhi umshololo kanjalo naye ukuthi akasivumeli isicelo sokuthi icala lisele emuva ukuthi ngempela.
Madam Interpreter, your voice is very low.
Thank you, my lord. Uthi-ke nayo ummeli umshololo naye akajabuli ukuthi icala libuyisele emuva futhi namhlanje. Naye ukhalaza ngokuthi ufakazi lo ongekho namhlanje akuyena kuphela ufakazi okhona ecaleni. Bakhona abanye ofakazi abala eGoli abangabizwa. Angeke nje kuvumeleke ukuthi icala libuyisele emuva ngenxa yofakazi oyedwa nje oseThekwini. Bebe bekhona abanye ofakazi abathintekayo kuleli cala ebebekhona endlini ngelanga lokwenzeka kwalesi sehlakalo. Nommeli kanjalo umshololo uyakhalaza ukuthi bangathi icala lingaqhubeka ngabanye ofakazi abakhona abatholakalayo lana eGoli.
Mr. Advocate Baloyi, the point that the legal representatives are making, my only problem was when Mr. Tovane started sounding like he's dictating who should be called next. But I think the points they are making are founded. When you line up your witnesses, you know where they will travel from. And possibilities are always foreseeable of problems of a witness failing to be here for the one or the other reason. In this country, there are so many reasons. What you are saying, that the flights are full, there could be a strike somewhere, there could be anything that prevents somebody from arriving here. And they are saying there are other witnesses. And indeed, I would have believed that because this incident took place in Gauteng, there will be witnesses who will come from Gauteng. And the point they are making is that any of those can be called.
Yes. Indeed, my lord. The fact of the matter is this, we want to present the evidence in a certain order. This also is just not a question of leading, any evidence. We want to present the evidence in a certain order where, the various pieces of the jigsaw puzzle, fit in, so that, the court can also follow the evidence. And the submission, my lord, that this is a delaying tactic, it's not correct, my lord. This is, as I say, just a request that we stand down to tomorrow. It's just a couple of hours. And my learned friend, on behalf of accused number 5, mentioned that the witness that we intend coming comes from Durban. It's not correct, my lord. It's from a different destination. The other problem is that we are scheduled to sit until Friday. it will not make any sense to call a witness now, and when the witness who comes from very far, or call a witness whose evidence might overlap, and then tomorrow when the other witness comes, we ask that witness to stand down in order to proceed with the witness who comes from far, and that witness evidence stands over, because we foresee that the witness will be testifying tomorrow will be in the witness box for some time. So that would mean that the witness that we might have to call will have to stand down until the next court session, which will be sometimes in November, the 14th of November. So that witness will then have to stand down for about 2 months. Those are some of the considerations. And coming to the submissions of Mr. Tobani, a witness is called for a specific reason, my lord. You don't just call a witness. We call a witness to try and assist the court to adjudicate the issues that are in dispute. And we've explained that to my learned friend that we will inform them in advance of the witnesses that we intend calling in a specific segment so that they can prepare for those witnesses.
He seems to be favorable to a situation where you tell him of all potential witnesses who will be called, who will not be called. And the point is, I think the point is that the defense might need to call witnesses that the state doesn't call. So it seems to speak to aspirations towards preparedness on the part of the defense. That's what he seems to be seeking. And what is your response to that?
My lord, 2 reasons. Firstly, as explained, there are certain admissions that we must still discuss, and that those admissions might obviate the need to call further witnesses. So it is almost impossible to tell them beforehand, which witnesses we are not going to call, and it also depends how the case pans out. And secondly, the safety of the witnesses, my lord, is of paramount concern, and we don't want to readily disclose, which witnesses will be testifying. But as I mentioned, my lord, we will always inform the defense in advance the witnesses that we intend to call, on a specific topic of the evidence. And lastly, I've informed my learned friend that at the end of the state case, all the witnesses that the state will not have called will be made available to the defense. So they will then have the opportunity to consult with those witnesses and to call them should they wish to do so. And ever since this proceeding started, I think it's for the first time the defense has asked postponements. This is for the first time that the case cannot run because a witness is not available. And my lord, in any trial these things do happen. We have tried our level best to avoid this situation, but as I indicated, this is due to a situation beyond the control of the state. But tomorrow morning, the witness will be here, and we will be able to proceed. I did indicate to my colleagues that we made an alternative arrangement for a witness to be here today, and the estimation was that that witness will be able to testify today and finish, that witness evidence. But I only received a message this morning, very early this morning, that the witness has asked that his evidence be rescheduled. So yeah, that's the situation we find ourselves in, my lord.
Having listened to all sides, it is my view that the issue, and I think I've just mentioned it earlier on, the issue of a witness from afar warrants preparation that is beyond what I think was done. The fact that no flight was available simply says that flight arrangements should have been made earlier, because they wouldn't have been unavailable forever in the past. They would have been available and they would have been taken up as time drew closer. I understand the problem that the witness could have arrived in Gauteng and stayed over time without being called, but I think the importance we should read into this case and the dynamics that are going with it dictates. I know that I'm speaking after the fact and it might not be much to say now after everything else, but for purposes of the future, where there are such witnesses featuring, my sense is that arrangements should be made in time. I know it is not possible to predict how long some particular witness will last, but because of the nature of this case, I think we should have alternatives all the way. Stopgap measures should be lined up all the way so that this case flows, and so that we don't have glitches of the sort we are having today. At the end of the day, I grant the application to postpone overnight. However, I reiterate that in future we should do our all to avoid this. Even if we have to insert a witness in between to avoid a gap like this, I think we should, because everything is recorded. It will be clear on the record where that witness featured, and I don't think it will be that way all the way. It will be an exception rather than the rule. But the long and the short of what I'm saying is that the application for a postponement overnight is granted, while the state is urged to try its all to avoid gaps of the nature we are having today. So, having said that, may the accused rise. Due to the unavailability of the next witness, who got delayed because unavailability of flights from a particular destination, this case is postponed overnight to the 12th, to the 13th of September 2022. The accused shall be in custody.
Ngikugcizelela nje inkantolo kakhulu ukuthi ushishisi noma umbuso uzame-ke ukuthi wenze amalungiselelo afanelekile ukuthi kungabuye kube khona isikhala esifana nalesi eqhubekeni kwaleli cala. Ngizobuya-ke kusasa ngoba 12 September lana e-court beqhubekele icala.
This is Your Lordship. I do abide by the court's decision. However, we would like to give the state a notice for in case of this situation might happen again. We give a state notice in terms of section 342, capital letter A, Your Lordship. As court business.
Advocate Mshololo. from, he said we. So it could mean everything. It could mean anything.
I apologize, Your Lordship. When I say we, I mean the defense of 1 to 4.
Okay.
Thank you.
Thank you, my lord.
Advocate Baloy.
As a court, please, we've taken note of the submissions of Advocate Tobane. Mr. Tobane, I'm sorry.
You said in terms of section?
342, capital letter A, Your Lordship, of the Criminal Procedure Act.
I just point out, my lord, that as far as I know, such notice must be in writing.
No, he's just giving notice. You are saying the notice should be in writing.
No, I'm just saying the section requires such a notice to be in writing.
Doesn't happen like that. That's not correct, my lord. The application in terms of section 342A can be brought. There is no need for it to be brought under a formal application.
I take it we are not arguing the point now. I think that's the homework for everyone.
Now the state is starting to respond and read the
No, I mean, I don't think he will. There's no application now.
there is no need, my lord.
Yeah.
The court can adjourn, my lord, before we all open our criminal procedures.
Yeah, let me note before you check me out of the court.
I've just had a quick look. 342A subsection 4 requires that it says such a notice
My
must
lord,
be.
if he continues to address the court, it means we'll have to respond.
Mr. Baloy,
Thank you.
let's leave it for another day.
As a
I
court.
will also, I didn't see this coming. I know about 342 generally. I think myself, as I live here, I'm going to read it.
Thank you, my lord.
If anybody is asked, or immediately from now, what's the presiding officer doing in chambers, you can safely say he's reading section 342. Ashley? If you get me a copy of that. Yeah, as I said, the postponement is granted as indicated, and the aspect that Mr. Tobane wanted to be noted is accordingly noted, and the state indicated that it is aware of what Mr. Tobane has indicated. And with that, we come to the end of our proceedings today. The court shall adjourn.